Hello and welcome. Before I get into the TB Investigates article, I wanted to share some photographs I took while I was stuck in traffic in Boston yesterday. The sky was so blue and so clear. It's like unusual to see that around here in Massachusetts, especially in the Boston area. Beautiful blue skies. And I travel to the Boston area maybe once every month or once every other month, depending on what I'm doing, whether it's outreach or activism or supporting Karen Reed. The skyline. Beautiful blue skies. All right, let's get into the TB Investigates. This TB Investigates was posted today, just a half hour ago, by Aidan Kearney. It is titled Canton Cover-Up Part 484, Hank Brennan's Opposition to Motion to Dismiss Blames Everything on Adam Lally and Canton Police, debunked by a screenshot of videos from first trial. And he provided a split image of Adam Lally doing this stupid shh with his finger. Shh, don't tell them. Oh, he's such a jerk. Okay, and the Sallyport video of Karen Reed's SUV and the ghost individual that was in there. It begins, yesterday, Spanky Brennan and the Commonwealth filed their opposition to Karen Reed's motion to dismiss, and it's as pathetic as you imagined it would be. He claims that the defense never filed a motion to preserve surveillance video from the Canton Police Department, so they didn't violate Rule 14 because surveillance video wasn't included on the defense's list. And that already rings like bullshit. And, Aidan is citing a segment from the motion, the opposition, and it reads, despite claims to the contrary, the defense never filed a motion to preserve, or in its perpetually evolving theory of the case, did the defendant specifically request, prior to November 2024, surveillance video from the Canton Police Department, the police station, and there's a footnote there, number 1. But just look at how it's characterized, perpetually evolving theory of the case. Like, the defense does not deserve that mischaracterization. It is not perpetually evolving. In fact, it's the prosecution who has perpetually evolving evidence. It's the prosecution who is still submitting evidence to the defense team 3 years after the event occurred. Okay, guys, the prosecution has no room to talk about the defense and an alleged evolving theory, which is not evolving. It's been consistent. All that has changed is that with the incoming of new evidence, they were better able to establish that scientifically there is no way that Karen Reed could have done this. Initially, Karen Reed was willing to take responsibility. She didn't know what happened, but she was willing to take responsibility, you know? But that changed as soon as the information, the evidence was updated, and as soon as the federal investigation was put on display, and with the ARCA experts proving that John O'Keefe was never hit by an SUV. This is yet more mischaracterization from the prosecution, and again, it is abusive. And the article continues. Aidan says, but they clearly did. Number 3, all turret tapes from any local police department and the Massachusetts State Police regarding this matter from the first time the police were contacted to the arrest of the defendant. So this is Aidan citing one of the preservation demands, one of the preservation motions from the defense. And in that preservation motion, it clearly states, all tapes from any local police departments and the Massachusetts State Police regarding this matter from the first time the police were contacted to the arrest of the defendant. So again, guys, that was a proven mischaracterization of what's actually going on with the defense team's theory and with the preservation of evidence, which again, even without the preservation order, the Commonwealth was required to do in order to avoid being guilty of Brady violations. The article continues. Spanky's reasoning, the defense asked for all physical evidence from the crime scene, and the Canton Police Department is not the alleged crime scene. There's a footnote here. Number 1, the defense claims their February 2nd, 2022 request for, quote, all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene, end quote, was sufficient notice to the Commonwealth to preserve footage from the Canton Police Department, Sallyport, where the defendant's vehicle was stored for approximately 2 days. Defendant's Exhibit A, the Canton Police Department is not the alleged crime scene. The Commonwealth could not reasonably have anticipated the defense's ever-evolving third-party culprit claims, nor to this day made the Canton Police Department video pertinent to their amorphous and fluid claims. Guys, amorphous and fluid claims? Disgusting. Again, Hank Brennan, I'm not going to feel sorry for you when all of this inevitably, like it's going to happen. It will bite you in the ass, Hank Brennan. Good luck. The article continues. Yet Nicholas Guarino referred to the Canton Police Department as the crime scene in a February 4, 2022 report. When he said that Michael Proctor picked up John O'Keefe's phone, quote, while on scene, end quote, Michael Morrissey previously stated that Proctor never went to 34 Fairview Road, and that, quote, the scene, end quote, referred to in this report was CPD. You guys see how confusing it is already? Again, like the more the prosecution lies about the facts, the more audience members who are not caught up on this case, the more those audience members are confused and the more they don't know what to think. I said this in past videos that Hank Brennan must have studied propaganda. He knows how to confuse information. And the fact is that the defense team has such great information. They have such solid scientific evidence that cannot be disputed. So it's pure desperation at this point from the prosecution to throw out false facts about this case in an attempt to confuse the public's perception of this case. It's so nefarious. It's so insidious. It's not okay. You know, and that Aidan Kearney himself has to clarify the record in his own publishings. Like, okay, I'm going to continue. February 4, 2022, to Detective Lieutenant Brian Tully, Norfolk SPDU, commanding Norfolk SPDU, from Trooper Nicholas Guarino, subject cell phone extraction and forensic analysis of a cell phone belonging to John O'Keefe, date of birth December 8, 1975. Number 1, on Saturday, January 29, 2022, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk District Attorney's Office responded to an unattended death of John O'Keefe. Provides his date of birth again at 34 Fairview Road in Canton, though through his investigation it was found that O'Keefe was a victim of a motor vehicle homicide. While on scene, Trooper Proctor secured O'Keefe's cell phone and brought it to the Norfolk DA's office for forensic analysis. Yeah, through his investigation, the non-investigation. They were already forming the narrative here. So clearly, there was no investigation. And how terrible. What a reflection of their expertise as members of law enforcement to jump to the conclusion that it was a motor vehicle homicide. You know, even without the cover-up, even without the fact that Michael Proctor was friends with the Alberts and the McCabes. Just to know that they were all okay throwing that conclusion out there from the get-go. They were all okay saying, yeah, a motor vehicle homicide. Totally. Just unreliable, and they should not be in law enforcement. Continuing with the article, it reads, the defense alleges that a new video given to them on January 28, 2025, from outside the CPD Sallyport garage is the correct angle to show the condition of Karen Reed's right taillight, but that the video is too blurry for them to see who was going into the garage or what the taillight looked like. According to Spanky, it's no biggie though, because the poor quality meant that neither side could benefit from the tape, and there was another video angle showing the car enter the garage. Provides a citation. The defendant cannot show irremediable harm to her right to a fair trial as it relates to the Canton Police Department surveillance video. While the January 28, 2025 production was untimely, the poor quality of the video makes it difficult for either party to benefit from. Furthermore, this video depicts the same event that was contained on the surveillance videos produced on April 4, 2024 and April 23, 2024, simply just from a different camera angle. Further, while the Commonwealth would argue that the videos from the Canton Police Station Sallyport are inculpatory, the defendant benefited during the first trial by suggesting without any substantive evidence that the poor quality of the video and/or gaps in time due to an improperly functioning camera system were caused by an improper police investigation and systemic police misconduct. Well, we all know what's factual. We all know what's reality. Everyone paying attention to this case. And it was in fact caused by an improper police investigation and systemic police misconduct. Again, the prosecution at this point trying to disprove any police misconduct is futile. It's too late. Much like Judge Bev last Tuesday trying to say that she was looking out for Karen Reed's rights to a fair trial. Too late. We're not buying it. You all had years to make the right decisions, and decisions after decisions, you have all proven yourselves to be corrupt. No one is believing your narrative. Continuing. Question, why is Karen Reed the only one who seems to want to see these videos? If the Commonwealth is so convinced she is guilty, shouldn't they be the ones trying to get these videos? Shouldn't Karen Reed be attempting to suppress the videos? Either way, the problem with the, quote, different camera angle, end quote, from the other video is that the right rear taillight can't be seen, which Spanky is well aware of. Thank you, Aidan. Absolutely. Absolutely. For Hank Brennan to play it down like it's the same vehicle, it's the same area, it's just a different angle. When in fact, the fact that it's a different angle is crucial because we're worried about that right taillight, you know? And the prosecution, the MSP, Canton PD, they have all proven to everyone paying attention to this case, all of those members of law enforcement and all those prosecutors have proven to all of us that they have gone out of their way to hide, destroy, and manipulate any evidence pertaining to that right rear taillight. Continuing, Spanky's defense seems to be, quote, "They never gave it to us," end quote. And he cites a segment from a motion. After inquiry, it was learned that an investigator obtained this video from the Canton Police Department in 2022, and it was placed in a physical case file and never provided to the prosecutor or multimedia assistant for download, although the prosecutor was wholly unaware of this video until recently. The Commonwealth does not dispute that the video was in its custody during the defendant's first trial. Had the prosecutor known about this video, it would have been produced as every other video known to the prosecutor was. Right. Sure thing, Hank Brennan. Had the prosecution known of the existence of the video, they would have produced it. Like, how are we supposed to believe that now in March of 2025 when they are still turning over evidence to the defense team? And, why isn't there any reaction to this, that it was placed in a physical case file? Why wasn't anyone disciplined about that? Why wasn't anyone scolding the police officers, the law enforcement who had that video file in their possession, in a physical case file? Why isn't Judge Bev reprimanding the chain of custody here? Never provided to the prosecutor? Is that real? Is that true? And if it is true, guys, again, why isn't Judge Bev doing anything about it? And why isn't the prosecution themselves? Why isn't Michael Morrissey himself doing anything about it? If that's the truth. They are all liars. It's pointing the finger. It's like that Spider-Man meme, or point the finger at every other Spider-Man, so to avoid all personal responsibility. They're such cowards, They come up with this lie, with this grand cover-up, and they are such cowards when it comes to owning their own bullshit. Continuing, but it doesn't matter. This is on the Commonwealth. It's their job to hound CPD until they get the videos, not blame them for not doing their job. Regardless, Karen Reed had a right to all of this video, and it wasn't provided to them, which is a Brady violation and warrants dismissal of all charges. During the trial, the defense received 2 videos, the inverted video and the dark video you couldn't see. Spanky claims that a video technician for the Commonwealth, quote, clarified the video footage, end quote, and on October 10, 2024, the defense received, quote, clarified videos, end quote, so that they could actually see what was happening. After the trial, a certified forensic video, this is from the opposition, guys, just clarifying. It reads, after the trial, a certified forensic video technician employed by the Norfolk District Attorney's Office reviewed the surveillance footage that had been previously produced to the defendant. Recognizing that the video was extremely dark and with minimal visible detail, the video technician clarified the video footage, and October 10, 2024, the Commonwealth produced to the defense clarified videos, reports detailing the forensic clarification process, associated hash values, and extracted still images from the Canton Police Sallyport. Furthermore, the video technician clarified video images from the Canton, and it cuts off there. The article continues, there is no excuse for not providing this during the first trial. Spanky claims that the non-inverted version of the CPD garage video was played by the Commonwealth at trial, but that didn't happen until the next day, after it was all over the news that they played the inverted video and didn't alert the jury. Spanky claims that the video shows Michael Proctor never touched the car and was standing feet away from it. Continuing with the citation. Let's see if it doesn't match up, but I'm going to read this citation. Video in the condition it was received, contrary to the defendant's representation that the Commonwealth's intention was to mislead or deceive the jury by introducing the, quote, inverted, end quote, video. Pulling away. Are you fucking serious, Hanky? Are you fucking serious? Quote, inverted, end quote. You got to put it in quotations. Was it not inverted? Was it not flipped? Just guys, like in your face gaslighting, like, quote, inverted, end quote, like it didn't fucking happen. Sorry. Continuing. The defendant fails to mention that after the defense altered the evidence to, quote, correct, quote, the image to appear consistent with the human eye, the Commonwealth played the entirety of the, quote, corrected, end quote, yet altered video, which reveals that Trooper Proctor is standing feet away from the defendant's vehicle and never touched the rear taillight. Further omitted from the defendant's filing is the fact that Trooper Proctor's DNA was not on the rear taillight. The right rear taillight. What the fuck? Like, oh God. Oh man, guys. Oh man. It's like logic that kills brain cells, you know? It's like worse than alcohol to your brain when a shitty prosecutor attempts to gaslight people reading into this case and confuse us about the facts. Trooper Proctor's DNA was not on the right rear taillight. Oh, so he couldn't have been there at the Sallyport because his DNA wasn't on there. Like, hello, he's a member of law enforcement. They always carry gloves with them, you know? Like, they always have hazmat shit to protect them against cross-contamination, you know, and pathogens. Like, it's irrelevant if indeed his DNA was not found on the rear right taillight. Like, give me a fucking break. Continuing. I said this a while ago, guys. I'm gonna need therapy after this case. Oh, it's so bad. Continuing. The video does not show that at all. You can only see his head, and it's unclear how long far away. I think it's a typo. How long far away from the vehicle he was. It's a couple typos. I think Aidan meant it's unclear how far away from the vehicle he was. He looks to be right next to it, but his body and hands are hidden. Conveniently so. Conveniently so, guys. Again, the prosecution has proven to everyone paying attention to this case that they have gone above and beyond to destroy any evidence showing the condition of Karen Reed's rear right taillight after she allegedly struck John O'Keefe. Whether it's CCTV footage, whether it's library security footage, whether it's ring cameras or security cameras from people's houses, from their front porches, you know, like not a single piece of footage was recovered from the prosecution, by the prosecution or by the law enforcement, showing the condition of the rear right taillight. Conveniently, no footage from anyone's house, from any business, or from even Brian Albert's neighbor across the street, Kelleher, not even his ring camera. Like, conveniently, guys, not a single security camera showing the condition of that rear right taillight after the event. And now the Sallyport video too, that they will invert it during the first trial. They will lie and say they had no opportunity to fuck with the right taillight. Right? Like they have gone above and beyond to lie to us about the condition of the rear taillight, the right taillight. The real criminals in the Massachusetts versus Karen Read case is actually Massachusetts. The article continues. On April 17, a day into jury selection, Chief Rafferty once again decided it would be a good time to send over some more video she forgot that she had lying around. Good job, Aidan. Yes, it was just lying around, fuck the chain of custody. Yeah, just shoved under someone's desk, hidden in a filing cabinet, under someone's glazed donut, right? Just some video footage lying around. Fucking Rafferty. And if you guys don't know, Chief Rafferty, Helena Rafferty, is the chief of police for the Canton PD. Continuing. It's not Spanky's fault, though, because he didn't know of its existence. And he cites a segment from the motion. It reads, Canton Police Department surveillance videos. Following that hearing on April 17, 2024, Lieutenant Brian Tully sent prosecution team members an email stating, quote, I spoke with Chief Rafferty. She reviewed the video of the SUV arriving at CPD. Exists and we should have it. I don't know. The email was written poorly. She reviewed the video of the SUV arriving at CPD. It's like it's missing a couple words. I think it should read, she reviewed the video of the SUV arriving at CPD and it exists and we should have it. Contrary to what defense represented on Friday, the video depicts the vehicle entering the Sallyport and crime scene tape being put up. She is putting it on a thumb drive for us to the event we don't have it. Oh, sorry. In the event we don't have it, end quote. So interesting. She is putting it on a thumb drive for us in the event we don't have it, end quote. But why wasn't it turned over sooner, guys? Continuing. The prosecutor had not previously received this video or knew of its existence. Subsequently, the prosecutor requested that both the Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video. On April 23, 2024, the Commonwealth, and it cuts off, and the article continues. Helena Rafferty and Adam Lally both need to be called as witnesses for this trial, and Lally should be recused as a prosecutor. These people shouldn't be able to blame each other at Karen Read's expense. I 1000% agree. It's passing the buck, right? Just pass the buck. It wasn't me who did it. It was the other Spider-Man who did it. Like such bullshit. Such total bullshit. It's entirely on the Commonwealth to secure the chain of custody. It was entirely their burden. This is their case. We would not even know about Karen Read if it were not for the Commonwealth trying to prosecute her. This is their case, and the evidence in this case is their responsibility. Continuing. Commonwealth is saying that they didn't hand over Canton Police Sallyport video because they didn't know it existed, because investigating officers didn't tell them about it. The first videos they handed over were on April 4, 2024, weeks after Karen Read filed her motion to dismiss. Thus, she could not include this devastating evidence of Rule 14 violations in the MTD, motion to dismiss. Weeks after Karen Read filed her motion. And guys, again, to date, the Commonwealth, the prosecution is still turning over evidence to the defense team. Like, again, this never fucking happens in any other case, but Hank Brennan and Adam Lally and Michael Morrissey and Judge Bev, they all want to gaslight us and make it seem like this is totally cool. This is totally normal. Nothing to see here. They don't even care how disgusting they all look. Aidan cites another segment of the motion. It reads, nevertheless, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor. Prior to that, the prosecutor had not been alerted to its existence by investigating officers. Promptly on April 4, 2024, the Commonwealth provided the defendant with 9 surveillance videos in its possession, consisting of video footage of the main driveway of the Canton Police Station and video files entitled O'Keefe Sallyport, 1/28/2022, 12 a.m. to 12 a.m., O'Keefe Sallyport, 1/29/22, O'Keefe Sallyport, 1/29/22. It keeps listing the different kinds of videos. Continuing, notably, the quality of the video is poor in certain portions. However, that is the condition it was recorded in and the condition in which it was received by the prosecutor. The Commonwealth has produced evidence that since January 2022, the Sallyport camera was replaced due to its defective condition. And during the first trial, the Commonwealth called the technology director for the town of Canton to testify about surveillance video systems throughout the town, and he was subject to cross-examination by the defense. And the article continues, and sure, the quality of the video is poor, but they've fixed the problem since then, so the next person framed for murder will have a better chance to prove their innocence. As has been pointed out by online sleuths, the Commonwealth appears to be lying about not receiving these videos before April 4, 2024. During the trial, the Commonwealth showed a folder of all their Sallyport videos, and several are dated June 2023. I'm going to zoom in. It's really hard to see. It's like blurry and faint, but I do see 6/2023 and a couple of 2024 dates as well. It continues, this wasn't an oversight, it was malicious. Adam Lally needs to explain himself. As for the jury tampering claims in the motion to dismiss, the Commonwealth confirmed that these were about Lieutenant John Fanning's overseeing of the jury, resulting in a juror who was making faces that she believed Karen Reed was not guilty, being dismissed on the final day of the trial. The juror was reported to have been speaking about the trial 6 weeks prior at a bar. And there's a citation. At no time did Lieutenant Fanning enter the Norfolk Superior Courthouse during the defendant's trial. Moreover, he never saw, let alone spoke to any member of the jury. Furthermore, there is absolutely no evidence that the dismissal of the juror was improper. Sure thing, and it's all blacked out, guys. There is absolutely no evidence that the dismissal of the juror was improper. Bullshit. It continues, the defendant's preposterous claim, one that Attorney Jackson has stated he had, quote, no specific evidence of, and quote, should be rejected outright. You know, Hanky, this entire case should be rejected outright. Continuing. Spanky complains that Alan Jackson said in a Boston 25 News interview that Fanning was, quote, the very person governing the jury, end quote. In a footnote Aidan is citing, it reads number 3 on February 17, 2025, Boston 25 News aired an interview with the defendant and Attorney Jackson, where Attorney Jackson stated that Lieutenant Fanning was the, quote, very person governing the jury, end quote. Attorney Jackson also stated, despite representations in this court filing, that he had, quote, no specific evidence of jury tampering, end quote. Audio and video of interview available. Okay. The article continues, but at no point does he or Ted Daniel ever mention the name Fanning. And I remember that, pulling away from the article, guys, I remember. At no point did Alan Jackson say that it was Fanning who was supervising the jury. He was merely pointing at someone, a member of law enforcement, supervising the jury. It's like Hank Brennan is spilling the beans. Hank Brennan is telling on himself. He is telling on the prosecution. What is this called? There's a term for this. It's a Freudian slip. Holy fuck. At no point, guys, at no point during that interview with Ted Daniels did Alan Jackson say a word about Fanning. He alluded to a member of law enforcement supervising the jury, which never fucking happens. A member of law enforcement who also investigated the case, and that never fucking happens. It's not supposed to happen. But look at this. It's so great for Aidan to point out. But at no point does he or Ted Daniel ever mention the name Fanning. Freudian slip. Hank Brennan and the prosecution knew that it was Fanning. Continuing. Brennan claims that Fanning had nothing to do with the jury and was simply working security outside. And he cites the motion. The executive branch of government is separate and distinct from the judiciary. The governance of the jury is solely within the power of the trial court and sworn court officers. The defendant's first trial raised significant safety concerns for both parties, members of the victims' families, witnesses, court staff, media, and the public. To effectuate both the defendant and Commonwealth's right to a fair trial, this court ordered a buffer zone around the courthouse. To enforce the buffer zone and maintain order, approximately 50 uniformed officers from the Massachusetts State Police and other local departments were deployed each day on foot, motorcycle, and bike in the area directly surrounding the courthouse. Additional law enforcement resources were available in proximity to the courthouse at the Dedham Police Station. As a superior officer assigned to the Norfolk District Attorney's Detective Unit, and the only supervisor who was not a trial witness, Lieutenant Fanning was one of the commanding officers who was involved in the safety of and peacekeeping efforts occurring outside the courthouse. And we know that's not true, but even so, even if he was, that would still be a conflict of interest. He shouldn't have been allowed anywhere around the courthouse unless he was going to testify as a witness. Trial court security juror dismissal. The defendants claimed that a lieutenant of the Massachusetts State Police was, quote, in charge of jury security, end quote, is patently false. At no time did Lieutenant John Fanning have contact with nor control or influence over the trial jury, nor was there, quote, jury tampering that deprived Miss Reed of her constitutional right to a fair trial, end quote. The defense's brazen misrepresentation previously proffered in media interviews in direct violation of the impoundment order of juror discussion and sidebars solely to mislead and it cuts off. The article continues. I was at almost every day of the trial. Not once did I ever see John Fanning. So interesting. This is Aidan Kearney saying that he was at the courthouse almost every day of the trial, and not once did he ever see John Fanning. And guys, all the supporters too. None of the supporters took any photos of John Fanning, and the the supporters take photos of everybody outside the courtroom. If the supporters would have seen John Fanning, he absolutely would have had his photo taken. And I doubt a single photo of Fanning exists outside the courthouse. This is all provable, so Hank Brennan just might have dug himself another hole. Good job, Aidan, for saying that, because it's implying that if Aidan didn't see Fanning and none of the supporters saw Fanning outside, like Hank Brennan is alleging, then Fanning must have been inside. Fanning must have been inside somewhere, like where the jury was deliberating, like maybe in Judge Bev's chambers, you know? He must have been somewhere in the back, out of sight from the cameras. Continuing, Aidan provides another citation, statement of Jennifer McCabe. In violation of the defense's discovery order to produce all reciprocal discovery, including impeachment evidence to the Commonwealth prior to the start of the trial, it was during the third week of trial on May 7, 2024, that the defense produced reciprocal discovery to the Commonwealth regarding location information of Jennifer McCabe's cell phone. 3 days later, on May 10, 2024, in anticipation of her trial testimony, the Commonwealth met with Jennifer McCabe, as it does with all its witnesses. As it does with all its witnesses, guys. Right. Remember that during the first trial, it was revealed that the McCabes and the Alberts were able to do training in the war room with the prosecution. The McCabes and the Alberts and Brian Higgins were all permitted to practice testifying with the prosecution. So they all already knew what they were going to say the day of trial. Okay, guys? They all already knew what they were going to say the day of trial. Continuing. On May 29, 2024, Lieutenant Tully wrote a police report memorializing the meeting and explained, when asked why her cell phone would have been in the area of the residence of Sergeant Michael Lank on January 30th, 2022, quote, Jennifer stated she was with Carrie Roberts, who was picking up her daughter at the residence. Jennifer did not speak with Michael Lank while at the residence, end quote, provides an exhibit. The Commonwealth produced Lieutenant Tully's, and it cuts off. And Aidan says, so basically Hank Brennan's response to the very serious allegations of the Commonwealth withholding evidence was, quote, it wasn't me, end quote. That evidence might have helped or hurt both sides, so no harm, no foul. And it concludes, in any court that actually sought justice, this entire case would be thrown out. But the problem is that Beverly Cannoni gets to make that decision, and the odds that any of this means a damn thing to her are slim to none. 1000% agree. Good job, Aidan. As always, good job. And guys, I more so read Aidan Kearney's content on TB Investigates. I more so read his content than watch him. It's just that I prefer to read his newsletters, and I prefer reading his newsletters for everyone watching, for everyone interested, so that you guys don't have to read it. But I will leave the link in the description below to this news article from Aidan from TB Investigates. And again, I might be attending the hearing on Wednesday, and I might attend the other hearing on Tuesday. I will keep you all posted. But thank you for being here. Good job, Aidan. And thank you all for watching.